lot more. We're learning more about the case. We're learning more about her. And some of this stuff is a bit shocking, to be honest. One being that according to Quadasia's attorney, Ari Williams, is that the key witness for the state, according to them at least, going through these 20 pages, had on noise canceling headphones. So the question is, did that person hear what they said that they heard? And then there's some conflicting statements based on other witnesses that were on that scene. That's one thing that we learned. Look, I had to break all of this down because it's so much information. They're basically saying here that there is not clear and convincing evidence that Quadasia Johnson murdered Romika Blackman with intent, intentionally here, and that they feel like she is not a threat and should be released either on home confinement or electronic monitoring. Also very interesting detail that came out of this was seeing that there is no video that shows the full picture of this killing.
And there were a lot of people out there.
There were a lot of people out there. There's cameras out there. We know.
Let me ask you something that might change how you see this entire case. What happens if Holly Johnson beats the murder charges? What if her self-defense argument works? What if the jury believes she was scared? What if they believe she was protecting her baby? What if they acquit on first-degree murder? Does Holly walk free? Most people assume they know the answer. Most people would be wrong, because buried in the charging documents is something most defendants never see coming. Something Holly's attorneys are allegedly dealing with right now. Something that could make the murder verdict almost irrelevant. I am about to show you exactly what prosecutors allegedly built. And when you see it, everything changes. Before I break down the specific charges, I need to explain something that happens in courtrooms across America every single day. Something most people never think about until they are facing it. Charge stacking. When prosecutors build a case, they do not pick one charge and hope for the best. That would be reckless. That would give the defense too many ways to win. Instead, they stack multiple charges. Different charges. Charges that overlap. Charges that serve as alternatives. Charges that catch you even if you slip through somewhere else. Think of it like a net with multiple layers. You might dodge one layer, you might even dodge two. But by the third or fourth layer, you are caught. Subscribe, because what I am about to show you is a masterclass in how prosecutors allegedly build an escape-proof case. In Holly Johnson's case, legal experts watching have noted something specific about how the charges are structured. The prosecution allegedly filed charges under multiple Illinois statutes. Each statute addresses a different element of what allegedly happened on September 8, 2025. If the jury believes Holly acted with intent to kill, one set of charges applies. If the jury believes Holly knew her actions would cause death but did not specifically intend it, a different charge applies. If the jury is unsure about intent entirely but believes Holly shot Romika, yet another charge applies. If the jury only believes Holly fired a gun in a dangerous location, still another charge applies. Each path leads to prison. Some paths lead to decades. Some paths lead to life. There is allegedly no path that leads to freedom. Hit that like button if you are starting to see how this works. Now, why does this matter for Holly specifically? Because her entire defense allegedly rests on one argument. Self-defense. She was scared. She was protecting her baby. She reacted to a threat. If the jury believes that, murder becomes difficult to prove. Intent becomes murky. The prosecution's main charge could fail. But here is what the defense may not have fully accounted for. Some of the charges Holly allegedly faces do not require proving intent to kill. Some of the charges do not care about self-defense at all. Some of the charges only require proving where Holly fired, not why she fired. That is the trap.
And argues that the responsibility to prove the case lies entirely with prosecutors. The defense says the state has not met that burden, pointing out that Johnson has no prior criminal history. She had a license to carry a firearm. Still, let's go through some of the pages of this document. The first few pages outlines why Johnson is claiming self-defense, saying she was protecting herself and her 6-month-old child that was in the car when Blackman, quote, ran up and swung. According to the filing, Blackman repeatedly threatened Johnson Johnson through phone calls and text messages. The threats escalated to the point that Blackman allegedly told Johnson's grandmother she intended to kill her. At the time, Johnson was pregnant and, according to her attorney, feared for her life and the safety of her unborn child. They also say an order of protection was granted months before the shooting, though we found one that was never delivered. Now, on the morning of the shooting, that was September 8th last year, Johnson was being driven back to her car by her child's father when Blackman unexpectedly arrived. She had just dropped off her son in that area. Both women have children by the same man. The motion claims Blackman allegedly blocked Johnson's vehicle, approached her aggressively and said, "I told y'all I was going to catch you."
That is the net. That is why charge stacking works. Self-defense might save Holly from murder. It allegedly cannot save her from everything else. Let me show you exactly what I mean. We are going to start with the most serious charges and work our way down through every layer of this case. By the end, you will understand exactly what Holly is allegedly facing, and you will see why legal experts say she may have no way out. Holly Johnson allegedly faces 6 counts of first-degree murder. But here is what the headlines do not tell you. First-degree murder in Illinois is not one charge. It is multiple charges dressed in the same name. Different theories, different elements, different paths to the same conviction. The prosecution allegedly charged Holly under 2 separate theories, and understanding the difference is critical to understanding this case. Theory 1. Intentional murder. Illinois Statute 720 ILCS 591A1. This is what most people think of when they hear murder: premeditated, planned, deliberate. Under this theory, the prosecution must allegedly prove that Holly specifically intended to kill Romeka, that when she pulled the trigger, her goal was death. The defense can fight this. They can argue Holly did not intend to kill. She was scared. She reacted. She did not have time to form intent. If the jury has reasonable doubt about intent, this theory could fail. Theory 2. Knowing murder. Illinois Statute 720 ILCS 59-1A. 2. This is different. This does not require proving Holly wanted Romeka dead. It only requires proving Holly knew her actions would likely cause death or great bodily harm. Did Holly know that shooting someone in the face 3 times would likely kill them? That is a much harder question for the defense to fight. Share this video because most people do not understand there are 2 ways to convict on murder. Here is why this matters. The jury might have doubts about intent. They might believe Holly was scared. They might believe she acted in the moment without planning. But even with those doubts, they can look at theory 2. Did Holly know shooting someone in the face would likely cause death? Almost certainly yes. Same conviction, same sentence, different door. The penalty for both theories is identical, 20 to 60 years base sentence. But Holly allegedly used a firearm that caused death. Under Illinois law, that triggers a mandatory enhancement. 25 years to life added to the base sentence. That pushes the range to 45 years to natural life in prison. No probation, no early release. Under truth in sentencing, Holly would serve 100% of her sentence. Now, what about self-defense? Self-defense can defeat both theories. If Holly reasonably believed she faced imminent danger, if she used proportional force, if she was not the initial aggressor, the jury could acquit. But here is what makes this case allegedly different: the stalking allegations. Reports suggest Holly allegedly tracked Romeka's location. She allegedly knew where Romeka would be. She allegedly chose to be at that location. If the jury believes those allegations, self-defense becomes complicated. Stalkers do not get to claim they were scared of their victims. But even if self-defense works, even if the jury acquits on all 6 murder counts, Holly is not free, because the prosecution allegedly built backup layers. Class X felonies that do not require proving intent to kill, charges that do not care about self-defense. Let me show you the first one. This is where the prosecution's strategy allegedly gets devastating. Aggravated battery with a firearm. Illinois Statute 720 ILCS 5-12-3.05E. 1. This is a Class X felony, the second highest classification in Illinois law, right below murder. But here is the critical difference. This charge is not about killing someone. it is about shooting someone. Under Illinois law, if you knowingly cause bodily harm to another person by discharging a firearm, that is aggravated battery with a firearm. The penalty, 6 to 30 years in prison. Under truth in sentencing, Holly would serve at least 85%. No probation allowed. The legislature specifically prohibited it for this charge. If you are starting to see the pattern, smash that like button. Why does this charge matter? Because it allegedly survives even if murder fails. Murder requires proving Holly intended to kill or knew her actions would cause death. Aggravated battery only requires proving Holly knowingly caused bodily harm with a firearm.
This new information, so since Ms. Johnson's last detention hearing, counsel has since had the opportunity to speak with her family, review discovery, and understand more about the case than previously proffered, as well as Mrs. Johnson's background. This new information constitutes a change in circumstance sufficient to warrant a redetermination of Mrs. Johnson's detention status, where this court solely relied on allegations that were made against Mrs. Johnson to initially determine her custody status. This court should reconsider its ruling and order less restrictive means. The state is unable to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great that Quadeja Johnson in fact committed this offense. The circumstances and facts of this case do not weigh in favor of any of the factors courts consider when determining whether a defendant poses a real and present threat to the safety of any person. Okay?
Did Holly fire a gun at Romeka? According to prosecutors, yes. Did that gunfire cause bodily harm? 3 shots to the face. The answer is self-evident. The prosecution does not need to prove intent to kill. They only need to prove Holly knowingly shot someone. That is allegedly documented. Video, witnesses, shell casings, the physical evidence. Now what about self-defense? Self-defense can apply here. If Holly reasonably believed deadly force was necessary, she could argue justification. But the same problems exist. The stalking allegations, the alleged digital surveillance, the claim that Holly tracked Romeka's location. If Holly was the one doing the tracking, she looks like the aggressor. Self-defense becomes a harder sell. And even if self-defense works on aggravated battery, there is another Class X charge waiting. One that does not care about self-defense at all. One that only cares about geography. This is the charge that could seal everything. The charge that allegedly cannot be argued away. Unlawful use of a weapon in a prohibited area. Illinois Statute 720 ILCS 5-24-1 and 720 ILCS 5-24 NS 1.2. Under Illinois law, discharging a firearm within 1,000 feet of a school is automatically elevated to a Class X felony. Not because of who you shot, not because of why you shot, because of where you shot. The penalty, 6 to 30 years. 85% must be served. No probation, no house arrest, no alternatives. Subscribe because this next part explains why location could be more important than intent. The law does not ask why you fired. The law does not care if you were scared. The law does not care if you were defending yourself or your family. The law asks one question: where did you discharge that firearm? If the answer is within 1,000 feet of a school, that is Class X. Automatic. 1,000 feet is roughly 3 football fields. That is the buffer zone Illinois created around schools. Holly allegedly fired her weapon near an elementary school in Chicago's South Loop. The shooting occurred during morning drop-off. Children were arriving. Parents were present. The location is documented. The school's address is public record. The distance can be measured. This is not a he said, she said situation. This is geography. Geography does not lie. Self-defense explains why someone fires a weapon. It does not change where they fired it. Think about what this means for Holly's case. Even if the jury believes she was scared, even if they believe she was protecting her baby, even if they believe Romeka was the aggressor, none of that moves the school. None of that changes the address. None of that alters the fact that Holly allegedly discharged a firearm in a school zone. This is why legal experts watching this case say the location charge could be unbeatable. Holly's defense cannot argue she did not know she was near a school. She allegedly tracked Romeka to that location specifically because of the school drop-off routine. Holly's defense cannot argue she fired somewhere else. The shooting location is fixed. It happened where it happened. Holly's defense cannot argue she had no choice. According to prosecutors, Holly walked to her car, retrieved her firearm, and returned. She allegedly had time to leave. She allegedly chose to stay. The school zone charge does not require the prosecution to prove intent. It does not require them to disprove self-defense. It only requires them to prove location. And location is allegedly the one thing that cannot be disputed. If convicted on this charge alone, Holly goes to prison. 6 years minimum, 30 years maximum, regardless of what happens with murder, regardless of what happens with self-defense. This is the trap. This is why charge stacking works. But the prosecution allegedly did not stop here. There is one more layer, one more charge, one more way to ensure Holly allegedly cannot escape. Reckless discharge of a firearm. Illinois Statute 720, ILCS 524-15. This is a Class 4 felony. 1 to 3 years, less severe than Class X. But it serves a purpose. This charge applies when someone fires a gun in a manner that endangers the safety of others. No intent to kill required. No intent to harm a specific person required. Just recklessness. Just firing in a way that could have hurt someone. Holly allegedly fired 3 shots near a school, during drop-off, while children arrived, while parents stood nearby. Even if every other charge somehow fails, the prosecution can allegedly argue this. Firing a gun in that location at that time was inherently reckless. It endangered everyone present. Intent does not matter. The act itself was dangerous. This is the final safety net, the last layer of the alleged trap. Now let me show you the full picture. If you see how thorough this strategy allegedly is, share this video right now. Here is what Holly allegedly faces when you add it all up. First-degree murder under 2 theories. 45 years to natural life. Aggravated battery with a firearm. Class X. 6 to 30 years. 85% served. Unlawful discharge near a school. Class X. 6 to 30 years. 85% served. Reckless discharge. Class 4. 1 to 3 years. Stalking charges reportedly adding 2 to 8 more years. 2 additional charges that remain publicly unidentified. Layer after layer. Backup after backup. The prosecution allegedly built a case where conviction on something is almost guaranteed, even without murder. Prison, even with self-defense on some charges. Prison on others, even in the best-case scenario. Years behind bars. That is charge stacking. That is how prosecutors allegedly ensure accountability. That is what Holly Johnson is allegedly facing. Now I want to show you something nobody is talking about. The defense's dilemma. The impossible choice Holly's attorneys allegedly face. When you understand what they are up against, you will see why this case may already be decided. The defense has one primary strategy: self-defense. Holly was scared. Romeka was the aggressor. Holly had to protect herself and her baby. But self-defense creates a problem. A big one. To argue self-defense, Holly has to admit she fired the gun. She cannot say it was not me. She cannot say someone else did it. She has to say, yes, I fired. But I was justified. The moment she admits firing, she allegedly admits to the school zone charge. The moment she admits firing, she allegedly admits to reckless discharge. The moment she admits firing, she allegedly admits to aggravated battery. Self-defense might save her from murder. It allegedly hands the prosecution everything else. This is the trap within the trap. Hit that like button if you understand why Holly's defense is in trouble. Let me show you the 3 paths Holly's attorneys allegedly face. Path 1. Fight everything. Deny the shooting entirely. This is almost impossible. There is allegedly video. There are allegedly witnesses. There are shell casings. The physical evidence reportedly exists. If the defense denies Holly fired the gun, they lose credibility. The jury stops believing anything they say. Murder conviction becomes more likely, not less. Path 2. Admit the shooting but claim self-defense. This is the most likely strategy. But it comes with costs. By admitting she fired, Holly allegedly admits to every charge that only requires proving she discharged a firearm. The school zone charge, the reckless discharge charge, potentially the aggravated battery charge. Self-defense might beat murder. It allegedly cannot beat geography. Path 3. Plead guilty to lesser charges for a reduced sentence. This would mean admitting guilt on some charges in exchange for the prosecution dropping others. It would mean prison time, but potentially less prison time than fighting and losing. We do not know if this option is on the table. We do not know if Holly would accept it. But it shows you the position she is allegedly in. There may be no path to freedom, only paths to different lengths of imprisonment. Now think about what Holly's attorneys are facing every day. If they fight everything, they risk losing everything. If they admit the shooting for self-defense, they hand the prosecution Class X convictions. If they negotiate, Holly goes to prison. There is no door-marked exit. There is only choosing which door leads to the least time behind bars. This is what charge stacking does. This is why prosecutors use it. This is why Holly Johnson may already be out of options. The trial will determine exactly how long Holly serves. But whether she serves at all may no longer be a question. There is a name that keeps coming up in this case: Carlos Smith, the man who was there when Romeka died, the father of children with both women. Some people think Carlos could change things, that his testimony could help Holly, that what he says about that day could make a difference. Let me show you why that may not matter. Carlos has spoken publicly. He denied the prosecution's claims about his involvement. He said he did not put Romeka in a chokehold. He said he tried to defuse the situation. But here is what Carlos has not addressed. He has not addressed the school zone. He has not addressed where Holly fired. He has not addressed the geography of this case.
Court today. Witnesses saying what they saw, but you were there. What's your reaction to what you heard came out in court today?
When I heard it, I'm just looking. It was unbelievable, but I was there. And I know for a fact none of that happened, how they just explained it. But my truth will get out here, and I hope everybody understand. That's really it. I can't even say too much right now. Because it's just gonna feel like I'm going against them, they going against me. We just going back and forth. But the truth is going to come out.
Because Carlos cannot change those facts. Nobody can. Share this video if you understand why location matters more than testimony. Think about what Carlos could potentially help with. He could support self-defense. He could say Romeka was aggressive. He could say Holly was scared. He could back up the narrative that Holly was defending herself. If the jury believes him, that might help with murder charges. But Carlos cannot testify that Holly fired somewhere else. She did not. Carlos cannot testify that the school was not there. It was. Carlos cannot testify that children were not present. They were. The Class X charges do not depend on who was the aggressor. The Class X charges do not depend on who started the confrontation. The Class X charges only depend on where Holly allegedly discharged her weapon. Carlos was a witness to the confrontation. He was not a witness to a different location. There is another problem with relying on Carlos. Carlos has his own credibility issues. Prosecutors allege he was involved. They claim he helped coordinate what happened. They claim he fist-bumped Holly afterward. If the jury believes the prosecution's version, Carlos becomes a co-conspirator, not a helpful witness. If the jury believes Carlos is lying to protect Holly, his testimony backfires. Carlos is not charged with anything. That itself raises questions. Why not? What deal was made? Whose side is he really on? These are questions the jury will consider. These are questions that could undermine anything Carlos says. But even if Carlos is the most credible witness in the world, even if the jury believes every word he says, it allegedly does not change the core problem. Holly fired a gun near a school. That is Class X. That is mandatory prison time. Carlos cannot undo that. Nobody can. When Romeka Meeks Blackman was killed, her family did not know if justice would come. For 90 days, they watched the woman accused of killing their daughter walk free. No arrest, no charges. Just grief and silence from the system. That changed when Holly was finally arrested. That changed more when the charges started stacking. And now the family understands something important about this case. It is not just about murder anymore. It is about architecture. The architecture of accountability. Subscribe because this is what the charges actually mean for the family. When prosecutors stack charges, they send a message. They are saying we are not leaving this to chance. We are not betting everything on one theory. We are building a structure that holds up even if parts of it fail. For Romeka's family, that structure allegedly means something profound. If murder fails, there are Class X charges underneath. If self-defense works on some counts, it allegedly does not work on others. If the jury has doubts about intent, they allegedly do not need intent for the school zone charge. The family is not just hoping for a conviction anymore. They are allegedly looking at a system designed to ensure one. This is different from what families usually experience. Usually, families watch trials with terror. One charge, one chance, one verdict. If something goes wrong, if one juror has doubt, the defendant walks. In this case, the structure allegedly works differently. Holly cannot walk if she beats murder. Class X is waiting. Holly cannot walk if self-defense works. The geography charge allegedly remains. Holly cannot walk even in the best case. She allegedly faces mandatory prison time on charges that do not require intent. For a family that has spent months demanding accountability, this allegedly represents something they rarely see, a guarantee, or as close to one as the legal system allows. Romeka's son is 7 years old. He will grow up without his mother. That pain does not go away regardless of what happens in court. But he may grow up knowing the system did not fail, knowing the woman accused of taking his mother faced real consequences, knowing the structure held. That is what charge stacking means to a victim's family. Not just a chance at justice, an architecture built to deliver it. Let me bring this all together. Holly Johnson allegedly faces 11 felony charges. But the number is not what matters. The structure is what matters. First-degree murder under 720 ILCS 591A 1. Intentional killing. 45 years to natural life with firearm enhancement. First-degree murder under 720 ILCS 591A 2. Knowing killing. Same sentence. Different theory. Back up to Theory 1. Aggravated battery with a firearm under 720 ILCS 512-203.05 E1. Class X. 6 to 30 years. Does not require proving intent to kill. Backup if murder fails. Unlawful use of weapon. Near school under 720 ILCS 524-1 and 24-1.2. Class X. 6 to 30 years. Does not care about self-defense. Only requires proving location. Reckless discharge under 720 ILCS 5 to 24-1.5. Class 4. 1 to 3 years. Final safety net. Plus stalking charges. Plus unidentified additional charges. Layer after layer, backup after backup. A structure allegedly designed to ensure conviction on something. Turn on notifications because Holly's next court date is February 3rd. Now let me answer the question I asked at the beginning. What happens if Holly beats murder? She allegedly still faces Class X charges. 6 to 30 years. 85% served. No probation. What happens if self-defense works? It might work on murder. It might work on aggravated battery. It allegedly cannot work on the school zone charge. Geography is not a defense. What happens in Holly's best-case scenario? She allegedly still goes to prison. For years. On charges that do not require intent. On charges that only require proving where she fired. There is no scenario where Holly allegedly walks free. The prosecution built this case to eliminate that possibility. They used every tool available. They stacked charges at every level. They created backup plans for their backup plans. This is how the system works when prosecutors are determined to secure accountability. Romeka Meeks Blackmon was 31 years old. She was a nursing student. She was a mother. She dropped her son off at school on September 8th, 2025, and never came home. The woman accused of taking her now faces a legal structure allegedly designed to ensure consequences, even without murder. Prison. Even with self-defense. Prison. Even in the best case. Prison. That is what the charges mean. That is what the stacking accomplishes. That is why Holly Johnson may never go home. The trial will determine exactly how long she serves. It will determine which charges stick and which fall away. It will determine whether she spends 6 years behind bars or the rest of her natural life. But whether she serves time at all may no longer be in question. The architecture allegedly ensures it. The structure allegedly guarantees it. And for Romika's family, that may finally be enough. Thank you for watching until the end. Like, subscribe, and share this video so more people understand how charge stacking works and what Holly Johnson is truly facing. Justice for Romika.